Senate Bill 144, colleagues, current law states that allows counties to charge fees for dozens of services provided by the public safety and justice system and allows them to set the amount of fees. This law has resulted in a patchwork of fees charged throughout the state with very uneven outcomes in each county. Senate Bill 144 seeks to reform the way we do business in our public safety and criminal justice system by ending the failed public policy for billing people accused and convicted of crimes for the cost of these services, even after they have served their time, and even though all of us are supposedly or purportedly beneficiaries of these systems. I want to be very clear. This bill does not eliminate fines, only fees. However, laws in the books and stakeholders often use the terms interchangeably. Most importantly, the differences between these sanctions are often blurred for those receiving bills as they are calculated and articulated as one large amount, often without any distinction. While the bill was on the suspense file, we surveyed families statewide. They identified the most egregious of the fees. Any fee that did not make this worst of the worst list were adopted as author's amendments. The committee struck a host of additional fees. The result is the amended bill before you that returned more than $60 million in fees to the courts and counties. Criminal administrative fees pose three main problems for cities, counties, and residents. Number one, they are charged to low-income people who can't afford to pay them. Two, they create barriers to reentry. And three, they are a self-defeating, anemic source of revenue. The criminal administrative system, as conducted by the courts and counties, was not designed to rely on fees. However, over the course of several decades, a series of events led to a significant increase in authorized fees, and then a significant decrease in collectible fees. The regressive, tough-on-crime era of the 80s and 90s leaned heavily on fees as punitive, despite the constitutional conflict, and to a lesser extent as financial support for the system. With the Great Recession came significant cuts statewide, cuts that we as a state are still recovering from. This increased the reliance for fees as a revenue source. With realignment, recent court decisions, and a better understanding about the once intractable problem of recidivism, the system now finds itself with a steadily declining revenue source. In 2018, this body heard SB 190 and voted to eliminate juvenile fees. In the less than 2 years since implementation, the counties are at 100% compliance with that law. In fact, some counties went beyond the law and have forgiven back owed fees, notably the largest county in the state, Los Angeles. In a 2018 study on the impact of probation fees in California, 58 public records requests were sent to all county probation departments. 80% of counties responded, representing nearly 95% of California's total population. Responses show that most counties do not track collection rates, suggesting that the fees are of little consequence to county budgets. Those that did track collection rates reveal low collection rates and a high cost of collection. Also in 2018, the City and County of San Francisco, by way of their Financial Justice Project, published the Criminal Justice Administrative Fees, High Pain for People, Low Gain for Government, a call to action for California counties. As a result of that published report, San Francisco abolished all locally imposed fees and fully discharged all locally imposed criminal administrative debt. In February of this year, the U.S. Supreme Court ruled unanimously that the prohibition in the 8th Amendment of the Constitution relating to excessive fines does in fact apply to state and local governments, thereby limiting their abilities to impose fines and seize property. Permission to read, Mr. President?
Without objection.
Thank you. In that ruling, Justice Ginsburg says, and I quote, "For good reason, the protection against excessive fines has been a constant shield throughout Anglo-American history. Exorbitant tolls undermine other constitutional liberties. And that the protection against excessive punitive economic sanctions secured by the clause is both fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition," end quote. This February, along with several of you, I attended the Smart Justice California retreat. Some of you in this room were there as well. The biggest takeaway was that victims who were present talked about their preference for a justice system that focuses more on rehabilitation than punishment, education than incarceration, and job creation and treatment. They talked about coming to that conclusion based on their understanding about what really helps recidivism rates. Last month, the LA County Board of Supervisors agreed to examine the application of fines, fees, and penalties and determine the feasibility of eliminating some or all of them. I've walked through this rather lengthy summary because I really hope to make clear to you that SB 144 is promoting a new vision for public safety, and we're not ahead of the curve. Communities, courts, counties, and evidence-based studies make it abundantly clear that the fees are, again, high-paying, low-gain. They perpetuate recidivism and are a constitutional challenge. Many of you I've had the opportunity to have conversations with who've expressed some concern. You've heard from your counties who will give you a dollar amount that they say this bill will blow a hole in their budget. I've strongly encouraged all of you to go back to talk to your counties to actually ask the question about collection rate and what fee they are paying or what administrative costs are associated with actually trying to collect these fees. We've had ongoing conversations about some of the particulars in the bill, specifically with regard to ignition interlock devices and others. And my point to you is really to allow us to continue this process with the bill. The primary letter of opposition states from the counties and those in opposition that they don't challenge the policy that we're attempting to address with the bill. The question is lost revenue. The question I pose to the opposition that I hope that you all will do as well is let's get a real clear picture of the true dollars and cents being debated. What kind of administrative costs are they incurring in their effort to collect the fees, and what are they actually collecting? Not what's owed to them on the books, but what are they actually collecting? We're not able to collect that data across the board, and until we do, I think it's important that we continue to push forward and have this conversation about whether or not it's appropriate to continue to charge people, some of whom have been victims of the system, some of whom have already paid their, if you will, for the lack of a better term, debt to society. And if it's appropriate that we continue to, on the backs of people impacted by these systems, charge them for what are, in effect, government services. Folks have asked me the question about what about not, charging those based on their inability to pay? Well, that's already in the law, and apparently it doesn't get implemented. From our coalition, there have been a number of meetings and conversations, and at a task force meeting, one coalition member asked a probation chief if they already did that. And the probation chief admitted that they really don't do the ability to pay determination in their county. They just charge everyone and attempt to let their collection agency deal with collections. Because the collection rate is so low, the amount the county spends on collecting these fees is a significant part of what's collected. Truly implementing ability to pay would just increase the admin costs. And since we know most people can't afford to pay, we'd be spending more public dollars to attempt to find a needle in the haystack, a rare defendant who has resources. So it simply is not cost effective, we believe, for most county departments and governments. With that, Mr. President, I'd ask for an aye vote on SB 144.
Thank you. Senator Hertzberg.
Thank you much, Mr. President. I rise in strong support of this measure. And I start with the basis of who we are as a people, and I would say that we have lost our way. When you study the reasons for punishment when people violate the law, whether it is taking away their liberty or imposing a fine, the purpose of a fine is to punish for an offense. That's its purpose, That's what kind of society we're supposed to be about. But we have lost our way. Let me give you an example. It costs $35 under our code if you run a stop sign. That's what it costs. That's the size of the fine, $35. But what's happened is we have used these processes to basically supplement and fund all sorts of government systems. There's a penalty assessment on top of that $35 for $40. There's a county assessment of $28, a Prop 69 DNA assessment. I don't know if you get a stop sign, what that means for DNA for $20. There's an EMT charge for $4, another surplus, another fee for other things. It's $238. $238. The test is not whether or not we're punishing people, but to be lazy and to use these systems to collect fees for all sorts of other things. And these are just a few of the dozens and dozens of examples. It's about punishment. What is the price of justice? We heard from the author on this that even though you're saying you're imposing all these bills, you're not collecting it. The legislative analyst did a report on 2013 and 14, $11 billion of unpaid fines. So let's see. You're imposing these fines, you're not collecting anything, and you're ruining people's lives that we heard about. The system doesn't make any sense. It's gone amok. We have lost our way. The Duenas case here in California, and I'm going to quote the decision of the court where they said, imposing unpayable fines and fees on indigent defendants is not only unfair, it serves no rational purpose, fails to further the legislative intent, and may be counterproductive, and I would suggest it is counterproductive. I understand that government needs money for other things, but you don't take it off the backs of people. We heard in other debates over the last few years on the floor of this House of the issues and impacts on folks' lives. We know that most folks can't even come up with $400 without having to borrow from a friend or sell something. We've heard that over and over again. I think what I like about this bill so much and what's so important is that it refocuses on us and be able to ask the appropriate questions, but not to put the burden on the back of everybody under these circumstances. I ask for your aye vote.
Senator Mitchell, would you like to close?
I would, and thank you for all my colleagues for a very rich discussion. I would just say briefly in terms of, is this bill now the appropriate action as opposed to further discussion or asking the counties, as has been done in any number of venues over the years, to come forward with their true numbers. I would just direct my colleagues' attention to at least just 3 reports that I happen to have here in my binder. Criminal justice administrative fees, high pain for people, low gain for government, a call to action for California counties, produced by the Financial Justice Project out of San Francisco. The problem with probation, a study of the economic and racial impact of probation fees in California, published by the Harvard Kennedy School, and Improving California's Criminal Fine and Fee System, the report by the Ledge analysts. And so I think it's an issue that a great deal of thought leaders have put their mind to really try to unwind a process that we acknowledge that we helped facilitate because of a struggling economy, because of a struggling general fund. That this was a way to continue to fund good work. And the question is it funding good work? The question is, what is it funding? And I would argue that we don't know. I would argue that the counties and the probation departments have had ample opportunity to come forward to provide clarity, and they have not. And so perhaps this could be perceived as the stick approach, and perhaps that's what's necessary for us to really get down to the nitty-gritty, if you will, in determining how counties are using these dollars paid on the backs of people who have been subjugated to our criminal justice system. As I've said before, the point of the bill and the point of me asking you to continue it to move through the process, I am sure it will be amended in the Assembly, which will give me the opportunity to come back and we can have a full discussion if it is successful and it comes back for concurrence. I've made commitments to many of you to keep you updated as we go along the process. I'm clear about the question around the interlock the ignition interlock devices. Again, the amendments we took in appropriations reinstated the fee to cover the cost for the program. It's the devices in themselves that we still have to continue to work out language that will be helpful and useful to all. Again, we took amendments and appropriations based on this statewide survey of those impacted by the fees to really see if we could find a sweet spot in terms of the fees that are the least egregious. And for people impacted by the fees, they were willing to step up and say, we appreciate the goal of this bill, we understand the fiscal impact, and so we're going to weigh in terms of what fees we think it would be best to remain in. And $60 million is what's been put back into the coffer, if you will, as a result of us amending the bill to reinstate some fees. So I think that we, the stakeholders, those who are paying the fees, have stepped up to the plate to have a meaningful, strategic, appropriate conversation about the public policy culture shift that we believe is appropriate to take place in the state of California. And with that, I hope that you will allow my co-author and I to continue to work on this really important public policy issue by allowing the bill to go forward by casting an aye vote today for SB 144.
Ayes 26, noes 8, the measure passes.